Welcome to the Stephen B. Kaufman podcast. I am your host today, Steve Kaufman, and we will be talking about estate planning. We live in very complicated and difficult times today. We're concerned about COVID, we're concerned about wars, we're concerned about financial issues, and many people, when they see me on the street or they come to my office, they're concerned about how to keep their finances and pass it on to their children or to their heirs or people that they love. And a lot of information that is disseminated in the streets is not accurate. And when they come to see me, we discuss a wide range of topics: powers of attorneys, bank accounts, trusts, and wills, and their concerns about a child, if they have no children, about a spouse, or if they don't have a spouse, about who gets their estate. People worked hard all their lives, they've accumulated some money, and they don't want the government to take it away. Well, the first step in dealing with these issues is to consult with a professional. When people come to see me, I usually don't charge for a consultation, and we discuss things. We spend about an hour dealing with different topics. What I would like to do today is to begin at the beginning. Many people want a will, and many people have heard about trust. These things are not in conflict with each other, but different types of documents and different kinds of beneficiary statements are suitable to different kinds of people. I would first like to talk about what is called non-testamentary transfer of assets. Not everything has to go by a will, and not everything has to go by a trust. This is not necessarily the best way of doing it, but people have questions about these things. If I have a bank account, and how do you list a bank account? Well, if you want to list it in your own name, you can do that. Or if you want some of the money to go to somebody else, there are two other things you can do. Most people are familiar with joint accounts, where you list your name with somebody else with the right of survivorship, which means whoever dies first, the assets in that account will go to the survivor. Then there's something called the Totten Trust, which is another bank account where you leave the assets in that bank account in trust for somebody else. The plus and the minus with the joint bank account is the person gets the money upon death. You just have to bring a death certificate to the bank. And the same thing holds true for what is known as the in trust for Totten bank accounts. However, one of the negatives with the joint account is if you don't trust the person, they could withdraw all the money and run away. That's not what you want to happen, but 95% of the time, people trust each other. The little bit of a bigger benefit with the in trust for accounts is it doesn't take effect until death. So therefore, somebody can't run away with the money while you're still alive. Now, let's talk about beneficiaries. If you have an insurance policy or you have an IRA, you generally name a beneficiary. So you would have an insurance policy where you own the policy and you leave it to a named beneficiary. All these things pass outside of a will and outside of a trust, whether it's a joint bank account, an in trust for account, or a beneficiary on an insurance policy or an IRA. Now, these things, when you talk about a will and you do a will, the will cannot deal with any of these things. So you got to pay attention. You might want to have, let's say, 3 children, everything go equally in a will, but you're leaving one of the children $100,000 in a joint bank account. By law, should you die, we always have to say God forbid, that money will go to the surviving joint tenant in that bank account. So they're getting an extra amount of money that you might not have intended. So you got to be careful with that. when you own real estate, one more aside, is you can list the real estate as joint tenants with the right of survivorship. Whoever dies first, that person's heirs will inherit it. Tenants in common is when the heirs of a person who dies first goes to that person's heirs. And when you're married, it's tenants by the entirety, which is practically impossible to break. I know I'm moving quickly, but these are what occurs when you take assets and you want to put it in somebody's name with yourself. So these things you have to bear in mind. These things I spoke about generally will not go into a will and will not go into a trust. So people come to me and they want to do a will. A will is a document that sets forth who you want to get your assets. Now, a will has to be signed according to a certain formula that's set forth in the estate powers and trust law, and you have to follow that rigidly. The will can designate whatever you want in that document. If you have 3 children, you can leave it equally to them, and you have an executor. What is an executor? An executor carries out your intentions as set forth in that will. They become the boss. Now, when you have a will, you search for assets that are basically in your own name. So as I said before, if you have a joint account, that doesn't go in accordance with the will. But if you have an account only in your name or a stockbroker's account, then that will go according to the will. A will is primarily a simple but important document. Some people say, "No, I need a will." Everybody should have a will. And I'll give you one brief example why. Your circumstances can change in the blinking of an eye. God forbid you have an automobile accident and eventually it's settled for $1 million. If you don't have a will, then that will not go according to your plans. So what happens if a person dies without a will? When you die with a will, it's called testate. When you die without a will, it's called intestate. Testate is Latin for meaning to speak. So if you don't have a will, you haven't spoken. If you have a will, you spoke. When you die without a will, New York State writes a will for you. And it has to go according to the blood. Let's say you have a nephew that you love. And you want the nephew, you have 2 children plus a nephew. Or you have a stepson, and you want them to share in your estate. Then you must do a will, because without a will, New York State will go according to the descent and distribution and according to the lineage that's established by the statute. So when you don't have a will, you also can't name your executor, the boss. Sometimes you want a certain person to be an executor, not somebody else. But if you don't have a will, it goes according to what is set forth in the statute. Also with a will, and you have young children, you can name who you want to be a guardian of your children, assuming that both spouses died. Without a will, the court will name the guardian, which is really a terrible thing to have happen. Under all circumstances, you want to avoid having to go to court, because the courts are bogged down and sometimes things will happen that you don't like. So therefore, you should do a will or a trust. I want to talk about 1 or 2 items and then I'll go into the trust. Many times people come in to see me and they want a power of attorney. A power of attorney is a document where you give the principal, an agent, somebody, the right to act on your behalf concerning your financial situation. You do what is known as a durable power of attorney, because should you become incompetent, then it still stays, it's still valid, and that person can act on your behalf. The power of attorney sets forth very broad powers or very limited powers. You can put in the power of attorney the power to do only one thing, sell your house. Or you could put in the power of attorney many different powers to act in behalf of yourself concerning bank accounts, concerning real estate transactions, concerning stock brokerage transactions. This is up to you what you want in the power of attorney. But you need to trust your agent, because if you have a runaway agent, they're going to run away with your money. I don't mean to scare people because it very rarely happens, but it can happen. So therefore, you need to have a good agent who respects you and do what you want. With all these things that we're talking about, it's your money. It's not your child's money. It's not your nephew's money. You do what you want with it. And when you do these documents and you do these things, you have to make sure that your wishes and your intentions will be effectuated should you die. I know we've spoken about a lot today. Should you wish to call me, my number is 718-822-0500, and you can call us at 855-4-Kaufman, 855-4 Kaufman, Kaufman. My website is www.sbk.nyc. Thank you very much. I hope I haven't given you a headache. Have a great day.